When we talk of mergers and these takeovers, there are two basic procedures. One, the transferee company takes over the debts of the transferor, or the transferor company retains sufficient funds to pay its debts. And the creditors will have to be involved, because the reason why takeovers and mergers happen is that one company is not able to meet its obligations. One company is not able to pay off debts satisfactorily. One company is struggling, the other company is doing sufficiently well. So they bring up that proposal. Can we take over your debts? Or can we give you funds to pay off, and then what you give us is control? You see, it won't be for free. It's either we take over your debts and own you, or we give you funds. We don't take all your assets, but you give up part of your control to us. But the creditors must be in the know-how of these transactions, because they're directly affected. In as much as the shareholders are affected, the creditors are directly affected, because if their debts are not paid, then they have the options of taking the company to court. They have the options of selling the assets. We talked about charges, where if it's a fixed charge, they have these options. Hanyurwa, we will go back to slide 8 about business combinations. We have not jumped it. We have not forgotten about it. We will go back to it once we finish on the mergers and acquisitions. Okay? So these creditors will be given a chance, because if they feel that their position is jeopardized, in that the new assets received by the transferor will not be sufficient to pay their debts, they can petition for the compulsory winding up of the transferor company on the grounds that it is unable to pay its debt. Where the interests are not taken care of, the creditors will do what they need to do to ensure they are not left hanging on these mergers and acquisitions. So we talk about reconstruction. And what is a reconstruction? We talked about company A, company B. Company B is making losses, and the financial position does not represent a true and fair view of the state of affairs of the company. And what we mean by this is that the assets are overvalued. They are not able to meet the obligations. If we have taken loans as a company, we have overcharged our assets, that if they're to be sold, we'll not be able to pay off the debts that we have. And the asset side of the balance sheet may contain fictitious assets or useless intangible assets, so that they give that assumption that things are okay. Yet things have not been okay for a couple of years. Things are not going to be okay in the near future. We will not be able to pay off our debts. We will not be able to meet our obligations. And when on the face of it, the financial statements show a higher net worth than what the real net worth ought to be, we overcapitalize the company. And once this is realized, then a reconstruction must be done. And a reconstruction is a process by which the affairs of the company are reorganized by the revaluation of assets, the reassessment of liabilities, and writing off the losses already suffered by reducing the paid up value of shares or varying the rights attached to different classes of shares. We cannot keep saying we have debtors, and there is no chance of us recovering these debts. When we say that we have assets, and yet in real sense, we are not able to convert the so-called assets into liquid cash when need be to pay off our creditors. Our creditors are on our backs, demanding payments. They again insist that we pay what we owe them. Once the company is found to be in that position, what it will do is to reorganize. It will revalue the assets, pay off, write off the debts that truly have no chances of being recovered. And where all the shares have been paid up, reflect these on the books of accounts. In so doing, that is an internal reconstruction. It's the company which has decided to look at its books of accounts, look at the assets it has, look at the liabilities it has, and look at how best these profit and loss and balance sheet can be changed to reflect the true nature and the true position of the company's accounts. And the objective is to reorganize capital or to compound with creditors to reflect the current status. This is done without liquidating the company or forming a new one. We do it and we bring the creditors on board. Tell them that we are not able to pay off these debts because we have charged that parcel of land more times than we are able to. If we were to sell it, we would not be able to pay off the debts we own. So this is internal and with the agreement of the creditors. And there is no liquidation that will follow up. But there's also an external reconstruction. And wherever an undertaking is being carried out by a company and is in substance transferred to another company, constituting substantially of the same shareholders, with a view to its being continued by the transferee company, then that is external reconstruction. When we move and accept that us as company B, we are in these problems, we have overvalued our assets, we have understated our liabilities, and company A comes and takes over the running, takes over these debts, takes over the assets, and essentially we are under its control, and they reorganize how things are done to enable us to survive, then that is external reconstruction. And when we talked of mergers, there are normally two types, where company A will go into voluntary liquidation and sell its assets to company B. And in return, the shareholders of company A will receive shares in company B. We dissolve company A, and the business of both companies are carried out by company B. And that is by agreement. And when company A and company B both go into voluntary liquidation, and we have a new company C formed for the purpose, then members of company A and company B will receive shares in company C. Companies A and B stop existing. And a new name is formed to cater for these new changes. And before this is done, as we have said, creditors are very key. So an agreement needs to be done with the creditors so that they don't take the company to court for compulsory winding up. And creditors, once they agree, and now their debts are charged to another company, a compromise or an arrangement will be done. So a compromise is where there has been previously been a dispute. The creditors are annoyed, you're not meeting your obligations. So we agree that company C is taking over, and company C will also take over the debts of company A and B. But an arrangement does not necessarily constitute a dispute. What we talked about, directors agree, it's friendly. We can do better together instead of us on opposite sides. So let us transfer or bring the assets together and we move on from there. So we can take a 5-minute break so that we come back and deal with the procedure of reconstruction. And we were talking about the procedure of reconstruction. So the first step is for the company or any creditor or any member, or if the company is being wound up, the liquidator, to ask the court to convene a meeting of creditors and each class of members. So the creditors should have a meeting of their own. The shareholders, ordinary shareholders, preference shareholders, if any, each class recognized in that company will have a meeting. And the company must send out the notice of any meeting with a statement explaining the effect of this scheme. We have discussed that we are going to do a reconstruction. We are going to look at our assets, we will look at our liabilities, and we will find a way that best suits how the going ahead, the moving forward will be done. The creditors need to have the meeting because it is in this meeting that they agree how will their debts be paid. The shareholders will have their meeting because if the company is wound up and the assets are distributed, what do they stand to gain? Also, what do they stand to gain if they agree to these arrangements that the assets available can only cover this much? And will they be called upon to miss out on the dividends for the next couple of years and such? So a meeting will be done, a notice of that meeting will be called, and this compromise or arrangement must be agreed at each meeting by a simple majority number that will represent 75% in value of those voting in person or by proxy. In meetings, we said when that notice is being sent, you also send out that proxy form to nominate someone to come act on your behalf. The creditors they do not vote in the sense of the shareholders. Theirs is to agree on how their debts will be paid. And where the necessary meetings have been held and the required majority has been obtained, 75%, then the court will give its approval. The Companies Act, in the arrangements and reconstruction, this is power to compromise with the creditors and members. We are talking about Section 207, where compromise or arrangement is proposed between a company and its creditors or any class. Then the court may, on the application of the company or any creditor or member, or in the case of a company being wound up, the liquidator. And what we have said, 3/4 in value. And you remember when you were talking why the registrar has an interest in the happenings of the company. You see, Section 3 says, subsection 3, that order will have no effect until the certified order has been delivered to the registrar for registration, and a copy of every such order annexed to every copy of the memorandum. And in the case of a company not having a memorandum, every copy so issued of the instrument constituting or defining the constitution of the company. And you're told about how much you will be fined. And this is what we are saying about the notice given. And then in every notice which is given by advertisement, you remember you can substitute if you're not able to get where all the shareholders are, as the case may be, because the registered office, you may move towns, you may move countries, and you substitute a notice by advertisement. But the essence is that every class must be made aware of the happenings. Every class of interested parties must be given a chance to vote on this plan that the company has. And lack of a notice again will make that action void. The Act clearly provides 3/4 must be present and voting. And in present, voting in person or by proxy. So what is the role of the court, having given the company the chance to do all this? So the court will ensure that the scheme is not ultra-vires. It is not beyond the powers given to the company. The memorandum gives the extent to which the company acts. So even this scheme that is being proposed by the directors and voted upon by the creditors and the members must be within the very essence of that company. And there must be proper use of the procedures laid down. We have read Section 207. Has a meeting been called? Has a notice been given? Has there been voting? So there is no improper use of procedure. The procedure has been followed. The procedure has been agreed upon. The court again will ensure the essence of a quorum, such that these 3/4 that is being required, the quorum must have been present. And the court will be careful if the majority of one class holds the shares of the other class, since they may vote in favor of a scheme which harms the first class of shares but benefits the second class. And this is where we are saying majority. Who owns the majority of the shares? So the court will look at the thought process behind this reconstruction. Is it being done to deny the minority shareholders a chance, or is it being done for the good of the company? And where it is seen that the majority shareholders, you can have the majority shareholders of company A and the majority shareholders of company B being the same. And where it's seen that their actions constitute a way of frustrating these minority shareholders, then the court may put a stop to this reconstruction process. And the court will also look into situations where creditors are also shareholders, because a similar conflict of interest could arise. In any instance, the creditors will want to protect themselves. And in the instance where they are both creditors and they are both shareholders, then they must act in a way that even the other minority shareholders are not left out. They cannot only act on their own behalf. So in general, the role of the court in this reconstruction is requiring disclosure of every information and to listen to any minority objections and it will only approve of this reconstruction scheme if it is one that an honest and intelligent businessman would approve. Why are we saying an honest and intelligent businessman? No businessman will want to enter into an arrangement where he's making losses or where there's no promise of the future. It's not short-term for a businessman. Any arrangement that he enters into, he foresees profit not only today, but for future generations even. So the court will look at an honest and intelligent businessman. Does this scheme make sense? In the larger outlook of the world, would it hold water? Or is it being done to frustrate the rights of the minority? And once it is satisfied, once the court is satisfied that not only have the procedures been followed, not only are the rights of minorities protected, and in the eyes of someone intelligent, an intelligent businessman makes moves that add money to his portfolio. He adds companies that bring more revenue. And it is this intelligent businessman we study. They're the ones who tell us to buy when prices are low and sell when prices are high. So if this intelligent businessman is not following these so-called rules of business, that scheme may be looked at under another lens, and the court may not, at its own discretion, refuse to allow that scheme of reconstruction to go on.